Hello, this is Attorney Brian Pendergraft with the Pendergraft firm. And today's video is when Maryland landlord companies do not need attorneys to appear in court. And that is, the statute I'll be covering today is Maryland Business Occupations and Professions Code, Section 10-206. And that is what I have pulled up in front of you here right now. So the default rule for companies such as limited liability companies or C corporations is that they require attorneys to represent them in court. So even if you are the owner of your own business, you have to hire an attorney to appear in court. So that is the price that you have to pay for limited liability protections. However, there are exceptions to this rule, and they are spelled out for us in this Maryland Business Occupations and Professions Code, Section 10-206, and that is what I have put up in front of you. So, but first, I have a few quick disclaimers. One, this is legal information. This is not legal advice. So rely on this at your own peril. Yeah. So, but if you would like legal advice, you can contact the local landlord tenant attorney. And my contact information is because it's in the description below if you would like to get in touch with me. And second disclaimer is that this video was recorded on, let's see, what's today's date? Today is January 6th. 2020. So if you're watching anytime after today's date, the rule may have been updated or it may have changed. So that's it. I will go through the exceptions for a when you do not need an attorney to appear in court. So let's start with this yellow section here. Except as otherwise provided by law, before an individual may practice law in the state, the individual shall. Now, if you appear in court and speak on behalf of someone else, that is considered practicing law. So, which is so it's I guess it's very, very broad application, I guess. So you must, one, be admitted to the bar, and two, meet any requirement that the Court of Appeals may set by rule. So those are people who meet those exceptions would be, let's say, who meet that rule would be an attorney, someone like me. That's actually, past bar, and I'm pretty sure I meet all of the Court of Appeals standards, whatever those requirements are. I've met them. I have to pass the bar and pay my dues and all that good stuff. If you don't do that, you can't practice law. You can't appear in court on behalf of other people. However, again, there are exceptions to this rule. And if you go here to Section B, you see I have this part here. This section does not apply to, so here's where it does not apply. A person while representing a landlord in a summary ejectment or a rent escrow proceeding in the District Court of Maryland. I probably should have highlighted District Court right there too, so it's clear that this can only happen in District Court. If you're in Circuit Court, you pretty much need an attorney at all times. I haven't seen an exception for a Circuit Court, but so if you are in District Court for either summary ejectment, i.e., a failure to appear in action, or a rent escrow proceeding, then you can use let's say, what do they call them? Rent court agents. That's what they're called, rent court agents. A lot of times rent court agents appear, but really anyone can be a rent court agent. It's not really like a qualification for that, So nevertheless, you can, but this exception is what carves out I guess, the rule, or I guess the lack of a rule that allows for rent court agents to do business, essentially. So that's what goes on there. So you do not need an attorney for failure to appear in actions and for rent escrow proceedings as long as they are taking place in the District Court. Now, moving on to, there's another exception here. Here's another exception. So we get skipping down a bit to Section 4. An officer of a corporation, an employee designated by an officer of a corporation, a partner in the business operated as a partnership, or an employee designated by a partner, a member of a limited liability company, or an employee designated by a member of a limited liability company, or an employee designated by the owner of a business operated as a sole proprietorship, while the officer, partner, member, or employee is appearing on behalf of the corporation, partnership, limited liability company, or business in a civil action in the District Court of Maryland, or an appeal from the District Court of Maryland. That was a very long mouthful. In fact, reading it like that, I don't think it was helpful at all. Yeah, that didn't seem very helpful to me, but let's see if I can make this helpful. All right, so let's go back up here. The section does not apply to, all these people here. we're just going to shorten this to, it does not apply to, I'm just going to say owners, I'm just going to say member of a business. It's probably the simplest way to think of it. But as you can see, there's a lot more than that. But let's keep it simple. So in this situation, you can, let's say, represent your business in a civil action. I should have highlighted civil action here just so it's clear it's civil actions. But in the district court or an appeal from the district court. So in other words, this action cannot start in circuit court. Now, the action must start in district court. It must be in district court. Now, in the appeal, it ends up getting appealed to a circuit court, and when actions are appealed to the circuit court, attorneys are not needed. But if they are started in circuit court, then an attorney is needed. All right, so, but the action or appeal, it must be based on a claim that does not exceed the amount set under section 4-405 of the court's article for a small claim action, and must not be based on an assignment to the corporation, partnership, or business of the claim of another, essentially. So your landlord business can essentially represent it, or you can represent your business in, let's say, district court, as long as it is a small claims action, essentially. And that is, what is a small claims action? It's in section 4-405 of the court's article. So now we're going to skip over to that so we can see exactly what a small claims action is. Alrighty. Oh man, my page that I had it set up so I could get right to it, and I gotta find it all over again. Oh, okay, good. It's still there. Good. All right, so section 4-405, this defines what a small claim action is. This court has exclusive jurisdiction over a small claims action. For the purpose of this section, now it's about to give us a definition, it means a civil action for money in which the amount claimed does not exceed $5,000 exclusive interest, costs, and attorney's fees. So again, cannot exceed $5,000. So if you're going for any amount, let's say you're going for amounts higher than $5,000, not including interest, costs, and attorney's fees, then you're in circuit court, or I'm saying no, you're not in circuit court necessarily. Scratch that. You're not in small claims court. You are in large claims court. And at that point, you need an attorney. So to represent the business. So if the attorney's fees are recoverable, let me continue. If attorney's fees are recoverable by law or contract in the landlord-tenant action under section 8-401 and 8-402 of the real property article, in which the amount of rent claimed does not exceed $5,000 exclusive of interest and costs. So again, so this is what this is saying is that specifically, I guess this is specifically regarding landlord-tenant claims and landlord claims against tenants in small claims actions, actually. So what this rule is saying is that the rent can get up to $5,000, and let's say there's attorney's fees on top of that, let's say the contract says that you can sue for attorney's fees, and so your amount ends up, say you end up suing for, I don't know, let's say $6,000 because you want like $1,000 in attorney's fees, so you're over $5,000. Then you can still go in district court. Essentially, it only counts does not count as a claim that is going higher than $5,000. Essentially, what they're looking at is the amount of rent. Is what they're looking at to determine whether or not it's a small claims action. So as long as the rent's less than $5,000, then then this can be made in what's it called, district court, essentially. That being said, if there are damages other than rent, and they're not attorney's fees, and the amount is higher than $5,000, then at that point, I think that you're going to need an attorney. Okay, hopefully that wasn't confusing and I explained that well. All right, so we are back to the business and occupations law here. So I have this section here. It's grayed out, but I graded out because I don't really feel like going over it. But this is saying that in the case of a designated employee, and then it says what the extra rules are if there's a designated employee, essentially. So if you want to send an employee on behalf of the business, they have to meet these requirements as well. And again, they're not assigned on a full-time basis to appear at district court. Two, they have to have a power of attorney, and they cannot be an individual who is disbarred or suspended as a lawyer in any state. And All right, so scrolling down to number, I guess 3 is here. Let's see here. The corporation, partnership, limited liability company, or business does not contract, hire, or employ another business entity to provide appearance services. So you cannot hire other businesses to appear on behalf of your business, essentially. And was that it? Was that all I wanted to cover? Yes, that is all I wanted to cover. So thanks for watching, and please like and subscribe. And if you have any comments, questions, disagree with my interpretation of the law, or anything of that nature, or I don't know, want to give me some feedback, yeah, just go ahead and drop a comment. All right. Thanks for watching.